Good afternoon. Happy Monday. I'm glad to see everyone. Let me make sure that I am live on all of the places that I need to be. I am glad to see you. Because of the platform that I am on, I don't know if you are participating unless you say something. So if you would be so kind as to let me know that you are here by dropping a hello, hi, how are you doing in the comments, then I will be glad to shout you out and to let you know that I see you. I'm glad to be here. I'm glad to be able to have a conversation with you um, about what has been going on in the Derek Chauvin trial. So, if you would be so kind, before we get started, if you could share this on your pages and your platforms. We are going to be talking today about the Derek Chauvin trial. Hey y'all, how you doing? Good to see you. Alafia, well, that's good morning. I have to learn how to say good afternoon and good evening, but I know you're going to tell me. But I am glad to see you. For everyone else who is present, if you would be so kind as to share this on your social media platforms so that we can get into a good conversation. That we can get into a good conversation, that you can bring your questions and your concerns. That would be absolutely wonderful. So let me say again officially, hello. My name is Natasha Robinson. I am the creator and curator of Legalese Please. Legalese Please is a digital platform that is designed to decode, to demystify, and deconstruct legal language. So we are all about the business of trying to understand what is the language that is currently being used so that we can convert that into language of liberation. All right. So I am glad to see you. Hello, Sora. Glad to see you. Hello, Ryan. How you doing? My brother and my friend, happy birthday to you. Hey, Jay Stone. How are you doing? I'm glad to see everybody. So we are going to go ahead and get started. Hopefully you have followed my instructions. If you are on YouTube, hello, I see you too. I'm glad to see you. Come on and have some comments for me, some questions. Hey, Andrea, how you doing? I said Andrea. It's Andrea. You know what I meant. Just hit Tamarine and charge it to my head, not to my heart. And also, we welcome you who will be watching this replay. We appreciate your presence and we appreciate you being here. So I'm going to get into it. I'm looking over here to my right, your left, because I want to make sure that I address everything that has been happening so far in the Derek Chauvin trial. The first thing that we know is it is not the George Floyd trial. It is the Derek Chauvin trial because George Floyd, unlike the defense, is not to be tried for his own murder. Okay. He is to be the victim because he is a victim. And the person who we are trying to hold accountable is, in fact, one Derek Chauvin, who used to be the police officer that was on the Minneapolis police force, but he is not any longer. He has been fired. And so now there are 3 charges that he is facing. He is facing manslaughter in the 2nd degree, murder in the 2nd degree, and murder in the 3rd degree. I want you to hold on to that. Hey, Dr. Kim. Oh, I did have it right. Andrea, I'm sorry. I'm very stickler for making sure people get things right. And so if I don't get it right, then correct me and let me know. All right. So anyway, I'm glad to see you. What is Derek Chauvin charged with? He is charged with manslaughter in the 2nd degree. He is charged with murder in the and murder in the 3rd degree, according to the Minnesota criminal statutes. Now, I want you to hang your hat on that and hold that because we're going to be talking about that in a little bit. Okay. But in case you did not know, you are at Legalese Please, where we are about the business of decoding, deconstructing and demystifying legal language, because we know that when the commentators are talking about different trials or what this means or what that means, we know a couple of things. One, not all of these persons who are commentating have legal experience in terms of being a practitioner or in terms of being an active legal participant. So they are sometimes commenting and giving commentary that is incorrect. And so sometimes they get it right, sometimes they get it wrong. And so I am here to make sure that we get it right. The second thing is, when you see this commentary, I have not seen it, but there is usually no question and answer period where the persons who are watching get to ask follow-up questions or clarifying questions. And so what happens is that the watcher is stuck, if you will, with what the commentary that has been provided. And so there is no critical analysis. And so sometimes it's just, you are supposed to eat what you were served. We're not here legalese, please. We ask the critical questions after we get the critical information. And so that is what I am here for today. We are going to be talking about a couple of things. And so because I am a professor as well as a preacher's kid, I have an agenda so that we're able to keep up. This is what we are going to be discussing today. We are going to be discussing actus reus and mens rea. We are going to be discussing the manner and cause of death. We are going to be discussing de-escalation and use of force. And we are going to be discussing police policies and procedures. And we're going to do this all in 60 minutes. One, because I don't want to hold you long. And then two, I have to go get my boss, who is my 4-year-old. And I want to make sure that I have sat somewhere and just kind of calm down so that I don't transfer that energy to her, because she's going to have enough energy of her own. Believe that. All right. So this is what we're talking about. Actus reus and mens rea. Wherever you are, I want you to say actus reus and mens rea. Okay, I hear you saying it, but I don't hear everybody saying it. Okay, so we're going to say it again. Actus reus and mens rea. All right, these are legal terms. And these legal terms, I'm going to save you a whole bunch of money by explaining it to you. Actus reus is referring to the criminal activity of the accused, which is synonymous with the suspect, which is synonymous with the defendant. Okay, actus reus is a Latin term that talks about criminal activity. Mens rea talks about the criminal mindset of the accused, of the suspect, of the defendant, meaning what is the defendant accused of thinking, or what is the criminal mindset that the criminal is accused of having at the time of the crime. All right. Now, if you're coming on and you're coming on a little later than when we started, please hit like, hit share, hit love, and then share it so that in the event that someone has some questions, you are able to provide the answers through me. All right. So first up, let's talk about actus reus and mens rea. Actus reus and mens rea are Latin terms that discuss issues involving the defendant. Okay, the actus reus is asking the question, what is the defendant accused of doing at the time of the crime? And mens rea is what is the accused, what is their mindset at the time of the alleged crime? So actus reus is criminal activity, mens rea is criminal mindset. Understand that usually every crime or alleged crime has actus reus, but not every crime has mens rea. Meaning, every crime has a criminal activity, or someone is accused of doing something criminal or illegal. Every crime does not have a criminal mindset, meaning there is no thought about what the defendant is thinking at the time of the alleged crime. Why is that? Actus reus means that there is criminal activity. So you can be arrested and held responsible for crimes which there was no intention, where there was no purpose, where you didn't mean to do it. Okay. An example I can think of here in Illinois is driving on a suspended or revoked license. You do not need to have meant to drive while your license is suspended. You do not need to know that your license is suspended, because this crime is called a strict liability crime, which means you don't have to have the mindset. You just have to have the activity. And so driving in Illinois was suspended as a crime. Also understand, in the state of Illinois, driving is considered to be driving, like moving somewhere, or in actual physical control, which means that your keys can be at the ignition. You can have the window rolled down, listen to music, and if your license is suspended and the police stop you or interrogate you, then you are guilty of that crime. Of course, there are some defenses, but for the most part, if you didn't know your license was suspended or revoked, it doesn't matter. If you did not intend to drive, you were just in the parking way of your house or a business structure, it doesn't matter. And I say this not because I've heard about this, but because I have represented clients who have been in these same situations. Okay, so that's an example. Actus reus is about what is the criminal activity, illegal activity that the defendant is accused of doing with their hands, their mouth, or their feet. Usually that falls within one of the three categories. Actus reus. What is the criminal / illegal activity that the defendant is accused of doing with their hands, their mouth, or their feet, or any combination of the three? Their hands. Are they holding a gun? Are they stealing something from a place where they have no business being? Their mouth. Are they giving threats? Are they lying under oath? Are they giving a false report? With their feet? Are they running from a crime scene? Are they engaged in some type of criminal activity where they have to go from point A to point B? Okay. Actus reus is the physical activity that could be deemed to be criminal. Okay. Excuse me. How is this important in the Derek Chauvin trial? I'm glad you asked. The actus reus, which, by the way, in court, they will never call it that. Okay. They will instead say that the defendant is guilty of the crime of this or the crime of that if the defendant blah, 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 and engaged in blah, 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 blah. So wherever you read the law or the statute and you see some physical activity or some prohibitions against doing something or saying something or being somewhere, that is the actus reus. That is the Latin term for actus reus. That is the first element of a crime. Usually, I want you to think of elements of crime like you think of ingredients to a recipe. If you have too much of an ingredient or not enough ingredient, or if you put in the wrong ingredient, you will not have the recipe or the outcome that you're trying to have. In the same way, if as a prosecution, every element or ingredient of the crime recipe is not proven, then by law, the defendant is supposed to be acquitted and found not guilty. Okay, so as it relates to manslaughter in the second degree, murder in the second degree, murder in the third degree, the actus reus is what did Derek Chauvin physically do that was against the law. Okay, now, of course, we can easily say, well, I almost cursed. I don't know how much more illegal you can get than you being a police officer in plainclothes clothes, sitting on top of a suspect who is saying that he is dying and is handcuffed and in custody. Again, why are we here? And what I said on the last live is there's a difference between factual guilt and legal guilt. Factual guilt is, yes, we all know Derek Chauvin killed George Floyd. But the legal question is, did Derek Chauvin's actions, his actus reus, did it cause the murder and the death of George Floyd, or was it in an array or a continuum of what was done to George Floyd? Because that's what the defense attorney is going to argue. The defense attorney is going to say, yeah, this was messed up. However, Derek Chauvin's actions are in a line of other things that happened to George Floyd before George Floyd died, such as the contaminants or the controlled substance of fentanyl and methamphetamine. They're going to argue that. They're also going to argue that that George Floyd was in bad health. They're also going to argue that the actions that Derek Chauvin took were justified. Okay, and we'll get to that. All right, so actus reus, that's your first term. That means the physical part of the alleged crime. What is it that Derek Chauvin is accused of doing with his hands, his mouth, or his feet? That's the first thing that the prosecution has to prove. The second thing that the prosecution has to prove is called the mens rea, which means what is the criminal or guilty mindset that the defendant is accused of having at the time of the crime. Now, because there is no uniform criminal code in the United States of America, that means that every state, every jurisdiction has its own laws. So what may be illegal in Illinois may not be illegal in Minnesota, may not be illegal in Florida, may not be illegal in California. So there were a group of people who were members of the American Law Institute. And they said, you know what? We got all these different states and jurisdictions. So what we're going to do is we are going to write some suggestions for you, the legislatures, to consider when making things illegal. Okay. And so when we're talking about the mens rea, that's Latin for what is the guilty mindset, then these are the things that was written up. The American Law Institute, I think it was 1966, 1967, wrote what is called the Model Penal Code. Now, these are not laws in themselves. Consider them strong suggestions. And so these legal professionals say, well, you know what? Your laws need to have the following mindsets in order to attach or ascribe responsibility. And what are those? The first is purposely. That means that that's the highest level of intentionality a person can have. And that is to be punished the most severely. The second is knowingly, meaning you knew or should have known that if you did A, then B was going to result. The next is recklessly, which means that you had, hey, Warren, which means that you had, you recognized that there was a risk and you did it anyway. Okay. And then negligently is you were not as careful as you could have been because you owed a legal duty to someone and you ignored it. So I'm going to say it again. If we were ranking it, purposely is the highest. It's punished the most severely because that means you meant to do that. There was no accident. Okay. In Illinois, the wording is also called intentionally. So purposely or intentionally, those are crimes that are punished the most severely. Then you have knowingly. Knowingly means you knew or should have known that if you were going to do this, then that was going to occur. Then you have recklessly. See, we are decreasing in punishment. Recklessly is you knew it was a risk and you disregarded it. And then negligently, which is you should have been a little more careful. Now, of course, if you look in the statutes and you are able to, hey, Anthony, hey, Dr. Grant, yes, this is L1L class, because I'm gonna break it down till it's forever broke, and then I'm gonna break that down. But yes, so think about it this way: is that when you are looking at criminal charges, you are looking to see what is the mens rea. Because if it's intentional, then that means that you chose to break the law on purpose, and that is to be punished more severely, generally, than, okay, I knew it was a risk and I just ignored that shit. I just, I was wilding out of control. Okay. Why is this important? Because the charges that Derek Chauvin is facing have nothing to do with intentionality or purposely. That's not what he's being charged with. So the most severe mindset, meaning he killed George Floyd on purpose. You're not going to look for that charge because the prosecution didn't bring that charge. They brought what I call lesser included charges, which means while there may be a mindset, it is not a mindset of intentionality or on purpose. He is charged with manslaughter in the second degree, which means that he is engaged in negligence because he created an unreasonable risk and consciously took chances of causing death or great bodily harm. Okay, the terminology is culpable negligence. Okay, then he's charged with murder in the second degree, which is I think maybe I got this wrong. He's charged with, I think it's the unintentional murder, which is talking about without intent to effect the death of a person. And then he's charged with murder in the second degree, which is, according to Minnesota, whoever without intent to effect the death of any person. Okay, so what does that mean for us? It means that he is not charged with intention or purposefully, okay, or even knowingly. He's charged with lesser included, which is to like, well, you should have done a little better. You knew something was off, but we're not going to charge you with the intentional death. We're going to charge you with unintentional death, even though you still killed him. Okay, so I just want you to be clear because, as I told you here, legalese, please, words matter. So when you have people talking about, yeah, that they everybody know that the evidence show on the video that he did it on purpose. He might have done it on purpose, but beloved, that's not what he's charged with. Okay, he's charged with reckless or negligent. Okay, even though the numbers for possible punishment may be high, that's not what he's looking at. Okay, so I just want to clear that up. If at any time, either doing the replay or doing the live, you have any questions or comments, put them in the comment section so that I can see your commentary. I'm going to take a sip of my water and then we're going to move on to the next one. All right, that was your break. So, actus reus, criminal activity, mens rea, criminal or guilty mindset. That's the first thing we're going to talk about. The second thing we're going to talk about is manner and cause of death. Now, when we are listening to the news, we hear if someone, let's say, for example, someone has been killed by the police. And then they say, well, the cause of death is homicide. And then we say, yay, that means that there's going to be a trial. That means that this person's going to be found guilty. That's not what that means. Okay. And so I am here to tell you what that means. All right. And I have with me, if you are in any form of criminal law, federal or state, whether you are a prosecutor, a defense attorney, or a judge, this is what we would call one of the Bibles. Okay, this is called Spitz and Fisher's Medical Legal Investigation of Death. All right, guidelines for the application of pathology to crime investigation. This is considered by many to be the Bible as it relates to criminal pathology, how people die, and in it are chapters like sharp force injury and injury by gunfire, thermal injury, strangulation, electrical and lighting injuries. And because of my training and my experience, I'm used to seeing this. I'm used to seeing that because that was part of my job when I was an assistant public defender. So within this are standards by which us as criminal professionals, we know. But this information is usually not passed to the public. All right. So the next thing we're going to talk about is manner and cause of death. These are two different things. All right. According to Spitz and Fisher, aka the Bible, think about this like a King James version, but not really. If King James wrote a book about how to determine death, this is what I think he'd write. Okay, so the manner of death is defined as purposes for vital statistics registration, meaning When someone says the manner of death is this, they are saying that for the purposes of the determination of death on the death certificate and how the death is to be computed in vital statistics. So in the Bureau of Vital Statistics, they keep up with how many births occur and how many deaths occur. And so when you're talking about the manner of death, there are only 1, 2, 3, 4, 5. There are only 5 manners of death according to Spitz and Fitzer. Here they are. Is that the manner of death for someone can be natural, which means it is caused exclusively by disease, meaning like a heart attack or something like that. Accident, which is the second one. Suicide, homicide, and undetermined. Those are the 5 manners of death. And when a coroner or medical examiner gives a manner of death, they are merely rendering an opinion to Vital Statistics Bureau as to how the death should be coded. So it is not a commentary according to the police. So if someone says the manner of death is homicide, that has no legal bearing. It is just saying we are basically talking in code to the Bureau of Vital Statistics and say, when you look at this death, you will either say it's by natural causes, it's by accidental causes, it's by suicide, it's by homicide, or it's undetermined. So what does homicide mean? Violent death at the hand of another person. That is no legal bearing to say that this person is the one who caused homicide. It's more of a administrative function. So when the examiner, the medical examiner and the coroner said the manner of death for George Floyd is a homicide, that does not carry legal bearing. It is simply saying when you go into your computer or when you go into your records, say that George Floyd was killed violently by the hands of another. Okay? Can we all understand that? That's the manner of death. Where we confuse manner of death is the cause of death. The cause of death, according to Spitz and Fitzer, aka King James and them, is the original underlying medical condition which initiates the lethal chain of events culminating in death. Meaning, what is the mechanism by which a person dies? It is with a weapon, or is it by a car, or is it by a gunshot, or is it by asphyxiation? Okay, that is more relied upon legally, in my opinion. So while you could say, yes, we can rely on the fact that this person was killed by another person, I want to know how they were killed. Okay, so in short, the manner is what do you label him? The cause is the how. Okay, the manner is what are you labeling? Was it natural death? Was it accidental death? Was it suicidal death? Was it homicidal death? Or was it undetermined? Okay, that's what are you going to label them? The cause of death is how did they die? That is where lawyers, prosecution, and defense, that is where we hang our hat. Because if we know how the person dies, then what we do is we try to establish the breadcrumbs to say that the reason why they died is because of this defendant. So in George Floyd's situation, George Floyd was the manner of his death was homicide because he violently died at the hands of another. His cause of death was by asphyxiation and everything else that the medical examiner or emergency room doctors testified to. Now, I have not now or ever been a medical doctor, so I don't get into the medical stuff. Like, I mean, I can tell you if a person is shot, I can tell you if it's close range, if it's long distance, if it's whatever, because of my training in terms of how to establish whether that outcome can be traced back to my client. Okay. But For us, all we need to know is that the medical doctors so far have said that whatever was in George Floyd's system, the fentanyl and the methamphetamines, they have said so far that had nothing to do with his death. And the only reason why he may have had some heart issues is because he had a freaking human sitting on top of his back, and he is not able to breathe or to expand in the way that he is created to do so, because he is trying to expand his whole body against a pavement which is made of concrete, with a whole human being sitting on top of his back and his neck. Okay, so the defense is trying to say, follow the magic ball. Okay, he didn't die because of Derek Chauvin. Derek Chauvin was just a factor of this. He really died because he was high, or he was addicted, or he was whatever. Okay, the prosecution is saying, no, no, boo boo. We have the medical evidence to show this is the reason why he died. Okay, so whenever you hear about any type of death, understand that the manner of death is one of the five: natural, accidental, suicidal, homicide, or undetermined. The cause of death is what is the instrumentation or the mentality, what is the method by which the person died. Okay, all right, so we clear on that. I'm putting this Bible back because it's heavy. Whew. All right, so that is the second thing. I'm looking at the questions. How did Trayvon Martin, Michael Brown, and Ahmaud Arbery die? Okay, so Trayvon Martin was shot, Michael Brown was shot, and Ahmaud Arbery was shot. Okay, that is the manner of death, because those were all homicides. But the causes of death had to do with how the entrance wound and the exit wound came out. Okay, meaning, was it a closed shot? Was it like in Michael Brown's situation? Michael Brown, the allegations was that there was a tussling match, and that Michael Brown was shot and killed. Ahmaud Arbery, that was where he was jogging down the street, and then the two people who thought he robbed somebody or something ended up shooting him. So they were kind of close range, I think. So remember, homicide is not the same thing of what we understand. The manner of death is homicide, but that does not give the legal weight that we need. We want to know, is it a homicide? That's pretty damn obvious. But it's the cause of death, meaning what is the reason why a person dies? In this case, the manner of death is George Floyd was a victim of homicide. But it's the cause of death, the how did he die, that determines whether or not Derek Chauvin is going to be found guilty or found not guilty. Okay, so I just want to clear that up. Okay, so next thing we're going to talk about is de-escalation and use of force, which was a big part of the testimony today. The main person who was testifying was the police chief of the Minneapolis police force. I can't remember his name, but he was direct examined by the prosecution, and he was cross-examined by the defense, who was representing Derek Chauvin. And something that they talked about is de-escalation, which is where you're trying to bring down, everyone's emotions, and you're trying to operate in a way that protects your life as a police officer, protects the life of the suspect, and protects those who are around. So they were talking about de-escalation techniques, but they also talked about the use of force. And I know that this is a hot topic in our community because there are a lot of conversations and different policies and procedures, which we'll talk about later, about use of force. The foundational United States Supreme Court case that they were discussing is called Graham versus Connor. Graham versus Connor. I'm going to type that in so that you are able to know about that. Okay, Graham versus Connor. That is a United States Supreme Court case. And what the Supreme Court decided, and I'm being very, very basic in my explanation. Okay, so I'm not giving you like I would give you an exam or an analysis in law school. Okay, but Graham versus Graham versus Connor was about a man who was having a diabetic attack, and he ran into this convenience store. There was a long line. So what he did, he ran back out the store. And when he ran back out the store, there were police that were in the neighborhood that thought that he was engaged in some type of criminal activity. And so then it went through the trial court, the appellate court, and then got to the Supreme Court. And then Graham versus Connor stands for the proposition on how police officers should approach investigatory stops and the use of force during an arrest. This case was decided in 1989, and the Supreme Court, as a unit, ruled that excessive use of force claims must be evaluated under the objectively reasonable standard. Okay, and there were some concurring opinions, and concurring means, yeah, I agree with the majority, but I want to write my own stuff so that y'all know this was my analysis. Okay, so what is the reasonable standard? The reasonableness standard is a test that asks whether the decisions made by the police officers at the time were legitimate and whether they were reasonable under the circumstances, meaning they're looking at the totality of the circumstances to decide if it was objectively reasonable for what the police officer may have done. So if George Floyd had remained alive, let's think about Jacob Blake. Jacob Blake, the young man who was shot by the police officers in Milwaukee. Let's say he's going to sue, and he's going to sue under the what's that statute? The United States Code, I think it's 1986, 1989. That doesn't stand for a year. It stands for the statute section, which says that the police officers were acting under the color of law, and you could not separate the police officers from accountability. But then as a result, you can't always sue the police officer directly. You have to sue their employers and the city and the state and all this type of civil stuff, which if I had my niece on here, she'd be able to explain that. But when a person sues for excessive use of force, or when they are alleging it, what they are saying is, according to the Supreme Court, you have to look at the objective reasonableness, meaning if you look at all of the different factors, can this person, can their position be understood by other people? And there was a lot of conversation about that, because what the prosecution is saying is that this was excessive use of force. It was deadly force. The police officer testified to the fact that this was a violation of police policies and procedures. And then when the defense attorney got up, the defense attorney said, well, you know, there were a lot of people around, and it's can we agree on the fact that because you are the police chief, you have not been on the street in an awful long time. So the way that you were trained and what you face may not be the way that Derek Chauvin is. It was just a whole bunch of stuff. And so the proposition that I want to stand for is one of the things that they are going to be arguing, or one of the things that is going to be an issue in this case, is the use of force. Was Derek Chauvin legally excessive in the use of force? Now you have the police chief who was saying, look, we don't have all of that, and we're trying to establish relationships between the community and the police. But one thing I found to be interesting is that when they were going through their examination, there were several police policies and procedures that were mentioned and used as exhibits in the questioning. And one of the exhibits said that you are to use the use of force to the degree of the alleged crime, which the way I understand that is, if I am trespassing, you are not coming after me as a police officer with a taser unless I escalate the situation and cause harm to yourself or to others. Okay. And even then, the taser is but one option. So, in case you didn't know, the whole reason why the police arrived on the scene on 38th in Chicago or 39th in Chicago in Minneapolis is because George Floyd was accused of using a $40 bill to buy some cigarettes. That's why the police were there in the first place. Because the clerk said, someone passed me a $20 bill that is fake. He went out, he asked George Floyd or whomever who was with George Floyd, can you pay for this? They said they already did. He went back into the store, the clerk did, and the manager called the police on George Floyd. And so whatever that alleged crime is of paying for a pack of cigarettes with the fake ass bill, that is using counterfeit money, which is against the law in the state of Minnesota. But the punishment for using counterfeit bills, which are less than $1,000, is a misdemeanor. That is the punishment that George Floyd would have faced. That is the eligibility bracket of punishment. Anywhere from supervision, which means the court monitors your actions, all the way to up to a year in prison. Okay? So that means if it's less than a year in prison, we call that a misdemeanor. Okay? But the reason why I'm bringing this up is because if Derek Chauvin, if you watched or had any inkling of hearing about this video, the use of force used against someone who was charged with a misdemeanor, a nonviolent offense, is disproportionate to what he was charged with. Okay? That would be like you stealing money out of your mama's wallet and your mama breaks your arm and then puts you out the house. The outcome is disproportionate to the reason that premeditated the outcome in the first place. It was excessive, it was uncalled for, and it resulted in the murder of George Floyd. There's also a quote, I tried to find it, but I cannot find it. But there is actually a document that is called the National Consensus Policy and Discussion Paper on Use of Force. I am going to put it in the comments. It is a free PDF. And this conversation, was revised July 2020. Okay. Why is that date significant? Because George Floyd was killed in May 2020. And that began to have the conversation of, look, we got to start changing some stuff. And it's not just about the policy that needs to be changed or the procedure that needs to be changed, but it's the training and, wait for it, the discretion by which police officers are to follow these policies and procedures. So my point on this as I wrap up is that you can have all of the policies in the world, but if you are talking about defunding police, abolishing police, reforming police, whatever language and intentionality you want to use, it is more than just holding police accountable. It is more than them just going to training. It is more than voting upon or having impact or insight into who gets voted or appointed as a police chief. We have to start paying attention to these policies and procedures. We have to understand the difference in the writing between shall and may. Shall is mandatory, like you shall, blah, 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 blah. and may is discretionary, which means you can do it, but you won't face any actions if you don't do it. We need to start paying attention to this. We need to start paying attention to the police officers and their policies in schools. We need to start paying attention to the policies that govern our cities and our villages. We need to start paying attention to who is elected, and we have to do it proactively as opposed to reactive. We have a bad habit of reacting to stuff after it's already legalized. Okay, we need to start paying more attention and being more involved. I understand that there is this saying that, I'm woke, I'm woke, I'm woke. Well, let me offer something to you. When I'm awake in the middle of the night, that does not stop me from stubbing my toe on something that I did not see. So my argument is it's not about being woke, it's about being alert. Can we be both? Can it be a both and? I'm not saying it's binary and be either or. I'm saying be woke and be alert. Be pay attention to what is going on around you. And just because it doesn't affect you now doesn't mean it will never affect you. Nor does it mean that because it doesn't affect you that you shouldn't be invested. Because if that's your child who's going through it, that is my child that's going through it. If it's your grandparents that are being treated like that, that means it's my grandparents. And we need to start getting more into the being part of the collective, part of the community. We should not have to wait until someone dies in our community or someone is mistreated in our community for us to finally get it and pay attention. Okay, the sharing of these videos, the participation in these videos is part of the community. I am here not because I don't have anything else better to do. I am here because I feel it is my calling to try and break down certain legal terms and to talk about certain cases and procedures so that you're not just woke, but you are aware and that you can sit down with your family and your friends. When we have these babies who are going to and from college and in person or virtually, we need to have conversations about what does the law look like in the state where you are going or in the state where you reside. Because if you're paying money for tuition in the state of Mississippi, guess what? Mississippi got different laws than Illinois. And you cannot say as a college student, I didn't know. Because you know what? I didn't know is not a legal defense. Okay. So when we're talking about roommate selection and when we're talking about getting all the cute paraphernalia and when we're talking about running for homecoming, let's have conversations about law, about what you need to know when you're out at night, about how to make sure that you're protecting your social media, about how you're being knowledgeable about who you ride in the car with, because if they have a gun or drugs or any other contraband, guess what? Everybody in the car is going to jail, whether you knew it or not. But if you don't have these conversations and if you are not proactive and loving, then what happens is by the time you do pay attention, sometimes it's too late. And it's my job to make sure that it's not too late for you. Okay? So I'm going to drink my water and I'm going to read these comments. If you have any questions or comments, put them in the chat so that I can read it. Okay. It has been reported Chauvin and Floyd had a previous relationship together and that they worked at the same nightclub in Minneapolis. How much of that bearing will that have on this case? It can go either way. It could be someone saying, well, that's the motive for killing him, or that's the motive for not killing him. Because if he knew him before, then why would he kill him now? Or it could be argued, well, because he didn't like him before, now this was his chance to really not like him in an extreme way. Okay. Floyd was a convicted armed robber, hard drug addict. Yes. And I ask you that because I want to know what is your relevance in saying that so that we can have a conversation. Any other comments or questions? Okay. Any other comments or questions? And I don't say and to be dismissive. I want to know, why is that relevant? That George Floyd was a convicted armed robber and hard drug addict. Even if that is true, I want to know, why are those pieces of information being brought up? Because nothing justifies being killed. Am I busy tonight? I stay busy. Any other questions or comments? And let me tell you this, if you have comments or questions outside of this place, you can email me at legaleseplease@gmail.com. And what that does is that allows me to have further conversation with you by way of written correspondence. Because sometimes, for those who are watching the replay or those who are watching now, you may have questions or comments that you may only have come to your mind after the broadcast is over. And so keeping in contact with me here allows me to answer your questions. Okay? The issue of drugs is being used as a distraction. Absolutely, because and you think about, and I'm just going to say a couple of names that I think of when I think about victim blaming or shifting the blame. Okay, are you ready? And this is in no chronological order. Breonna Taylor. Well, she's involved with a drug dealer, so her death must be justified because she used to date him. Trayvon Martin. Well, he's walking around with a hoodie in a neighborhood that technically is not his. So the neighborhood watch can treat him like they need to treat him. Tamir Rice. Well, that little boy had a little BB gun. And even though the fact that the dispatcher didn't tell the police officer that they thought it was a BB gun as opposed to a real gun, it's his own fault why he, at 12/13 years old, was murdered by a police officer. Eric Garner. Eric Garner is on the street in New York selling loose cigarettes. Why would you be selling loose cigarettes? Why don't you just engage in what is legal and profitable as an employment or as a job? Do you see where I'm going with this? It's always the decedent, the victim, who is being further victimized when you hear people saying, oh, I wonder what's going on with the George Floyd trial. There is no George Floyd trial. There is a Derek Chauvin trial. Think about Laquan McDonald. Oh, well, because he was slashing tires and running around with a mental health outbreak, he must be justified in being shot 16 times. Do you see what I'm saying? Why can't the taking of Black life just be that? Why does it always have to be a yes, but? Okay, that's the stuff that gets on my nerve. Okay. Hey, Sherry, how you doing? This is one of my colleagues that we were in the public defender's office together. So thank you very much. Yolanda says they could be detected in his system, but does not mean that he was intoxicated and under the influence at the time of the arrest. George Floyd is not on trial. Chauvin is. Absolutely. You're welcome, Deacon Flo Rule. I appreciate it. So the things that are in his system, they make no difference unless they cause some type of aggression or some type of factor that led to Derek Chauvin's response. So, for example, I had a murder case years ago where my client was charged with first-degree murder. And I said all day long to the prosecutor, to the judge, to my client, this is second-degree murder, not first. And for whatever reason, the prosecutor still went forward in the case with first-degree murder. And when they did a toxicology report of the victim was tested as having cocaine in the system. That was only relevant because one of the side effects of cocaine is aggression. So my argument was the reason why my client unjustifiably, but believably, he believed he was being attacked. The reason why he did what he did is because of the aggression of the cocaine in the system. That is different than just saying, well, because a person has this in their system, that automatically justifies the actions of the defendant. No, it doesn't. You have to tie it up by causation. Okay? You cannot just say, well, because George Floyd had fentanyl and methamphetamines in his system, that automatically gives a defense to Derek Chauvin. You have to tie it up. And if you have medical experts that are saying that his manner of death is homicide and his cause of death is him being asphyxiated or strangled, which is the effect of him losing his breath because of the weight upon him, then you have to show that as the main evidence and exhibit so the jury does not think, oh, he just died because Derek Chauvin was but one factor. The prosecution is saying, no, he's the factor. And that's the difference. I would be interested in the actual level of drugs that were found in his system. Fentanyl, meth does not stay in your system that long unless you use hair. Well, you're going to have to listen to the experts because that is a medical issue. It only becomes a legal issue if there is an argument that the effects of that caused George Floyd to be more aggressive or resisting or, what have you. What do I think about Adam Toledo and his death by the police? I do not know who Adam Toledo is. You will have to tell me. And then even if you tell me, I'll still have to do my research on that. The defense lawyer tried to use the excuse that the reason Chauvin remained on George Floyd's neck was to avoid him possibly responding violently when he came to. Now, I understand what you're saying, Yolanda, but if that is the assertion that is made in court, that's ridiculous. Because what the defense attorney is saying is that you apply enough pressure to me for me to pass out, but then when I regain consciousness, I'm gonna whoop your ass. I mean, that's absolutely absurd. That is almost similar to the argument that the defense attorneys were making for Jason Van Dyke and said, well, the reason why he shot him an additional 15 times is because Laquan McDonald wouldn't stay down. So we're going to shoot him repeatedly until we think that the harm that we are facing is over. So you can clearly see and hear how I feel about that. The young man who was shot by the police last week in Little Village. Okay, so in reviewing the news briefly, I think I saw a picture of his mom, but I did not read it, and I'm going to tell you why. Because even when I provide episodes like this or trainings like this or sessions like this, I am sick and tired of Black pain. I'm tired of analyzing it. I'm tired of looking at it. I'm tired of feeling the weight and the trauma. And even though I feel that there is a social responsibility to it, there are some things that even I refuse to watch or I refuse to read because that's still considered me consuming it. And I try to be on a figurative diet where I am particular about what I see and what I analyze. Because otherwise, I'll never get through the day. Now, that doesn't mean I'm any less active, but what it means is I consume what I know I can handle. And when I have had enough, that's it. I can tell you for certain that after this George Floyd trial ends, Legalese Please is going on a small hiatus because I need to be able to process what it is that I discuss, not just legally, but also emotionally and mentally and in a communal way. Okay. So I have to make sure that I am not subjecting myself to an exorbitant amount of trauma as well. Okay. But I thank you for bringing that case up because I did not know about that. At least I saw a blip of it and I just kept scrolling because I know that I am sensitive to that stuff. What you're doing is so very helpful. Thank you. Many people's perspective of the law and court proceedings based on Law and Order in first 48 episodes. Let me tell you, Yolanda, I tell my students all the time, when I am teaching criminal justice, you're not going to hear a dum dum, okay? Because Law and Order is designed to entertain. Okay, think about last week's episode when you had Lieutenant, well now Captain Benson and her partner, who came back, Stabler. Okay, I watched for entertainment. I didn't watch to get any legal analysis because if you're getting legal analysis, then guess what? It's not always going to be exciting. There are a lot of things that I see in Law and Order that I'm just like, that is illegal AF. Okay, Stabler going into the confession room and engaging in the investigation, and he is the victim. If I'm a defense attorney, there's no trial because all that stuff is getting dismissed. But that's not good television. Okay, that's not good entertainment. So yes, so it is what it is. All right. So I have gone over my time by 4 minutes. I told you I was only going to be on for 1 hour, and that is enough. With all hearts and minds clear, I'm going to end this broadcast. If at any time you wish to engage in a conversation with me, by all means, you can reach me at this email address, and I will be happy to answer any questions that you have. But thank you so much for being here. Please share this on your social media pages because this will get out the information that is truthful, the information that is accessible, and the information which is comprehensible, because I do want you to understand. All right. And once you understand, share it. All right. Thank you. Have a great day. I will probably see you on Wednesday. All right. You take care and have a great day. Bye-bye.